Hey everybody, this is Advocate Lucinda, your empowerment lawyer, and welcome to part 3 of my 12-part series on how to sue a police officer and a municipality under 42 USC 1983. In last week's video, we talked about how to serve the police officer and the municipality. Today, we're going to talk about the defendant's response. When a defendant receives the plaintiff's complaint, they have two options. They answer the complaint or they file the motion, the infamous motion, 12B, motion to dismiss. But for the purposes of this series, we're going to look at the defendant's response. And you want to watch this because I remember when I first started practicing law 31 years ago. I remember my very first civil rights lawsuit. The defendants answered it. It scared me. I didn't know what to do, how to start, where to go, but I know now. And I want to give you heads up on how to address the defendant's response to your complaint. So let's get started. So we're going to go over the defendant's response, what it entails, and what you should expect, and how you should respond. First, don't freak out like I did. And if you are one who has not gotten a response from a defendant, well, after this video, when you get a defendant's response, you will not be freaked out, but you'll be cool, calm, and collective. Okay? So let's start with the caption. The caption looks something like this, and we're going to continue with the fictitious case. We have the United States District Court, Northern District of somewhere, Plain Division. Lucinda Jones, the plaintiff, sees Police Department Chief Leonard Smith in his individual and official capacity, Officer Harold Jones in his individual and official capacity. Now, remember I said that some jurisdictions do not prefer that if you're going to sue the municipality, they prefer you did not name the individual officer in their official capacity, because naming an officer in his or her official capacity is the same as naming the municipality. So the defendant's response will start out something like this. Defendants answer an affirmative defenses to plaintiff's complaint. Chief Leonard Smith, Officer Harold Jones, and the City of Seas, by and through their undersigned counsel, hereby submit their answer and affirmative defenses to plaintiff's complaint as follows. Part 2, the answers. Defendant's answers. Note that defendant must respond to every single numbered paragraph in the plaintiff's complaint using one of these 3 standard responses. They must state, paragraph 1, responding to plaintiff's allegation 1, defendant admits the allegation contained in paragraph 1. With regards to paragraph 2, defendant lacks sufficient knowledge or information to form a belief as to the truth of the allegations contained in paragraph 2 and therefore denies them. 3, defendant denies the allegations contained in paragraph 3. And 4, Defendant denies the allegations of paragraph 4 except to admit that defendant Harold Jones was employed as a police officer on the date specified. You see what's going on here? They're going to either admit it, they're going to deny it for lack of sufficient knowledge or information, or they're going to outright deny it, at least in terms of answering the individual allegation, or they're going to deny it, part of it, and admit to part of it. Now let's go to our affirmative defenses, part 3, or defendants' affirmative defenses. You want to pay close attention to this, okay? Note, even plaintiff, if your allegations are true, affirmative defenses argue that the defendant is still not legally liable. Now, this is what the defendant is arguing. I remember first seeing this. Wow, I felt like I was wrong. No, what that means is that even if your allegations are true, they're still going to allege their affirmative defenses. In the 1983 cases, defendants routinely raise specific constitutional protections. So I want you to look out for these and don't let them worry you, okay? The first affirmative defense, failure to state a claim. The defendant is asserting that your complaint, plaintiff, lacks the necessary legal elements to win a lawsuit. 2, qualified immunity, the most common 1983 defense. They argue their conduct did not violate early established statutory or constitutional rights. 3, no municipality liability. They argue the alleged constitutional injuries were not caused by an official policy, custom, practice, deliberate indifference of defendant municipality. Because remember, when you sue a municipality, you got the state in some way that the practices of the police departments or the customs, so on and so forth, were the moving force behind the defendant's violative conduct. Are you with me? Okay. 4, statute of limitations. They argue you waited too long to file the lawsuit. 5, failure to exhaust administrative remedies. And this is common in prison 1983 cases, PLRA, which stands for Prison Litigation Reform Act, claiming you did not finish the internal grievance process before suing. 6, probable cause, false arrest / malicious prosecution claims, good faith. They're asserting here, to the extent plaintiff alleges unlawful arrest or seizure under the 4th Amendment, all actions taken by defendants were supported by lawful probable cause. Now, these are their assertions now. It don't make them true, but these are their assertions. And they are normal defenses that they use, okay? And 7, Heck versus Humphrey Bar, and you see where I put down the cite for this case. You need to read it. The defendants argue by citing Heck versus Humphrey Bar that plaintiff's claims for monetary damages are barred because a judgment in plaintiff's favor would necessarily imply the invalidity of an outstanding criminal conviction or sentence that has not been overturned or vacated. And part 4 of the defendant's response, their prayer for relief, what they were asked the court to grant on behalf of the defendants. Note, even if your allegations again are true, affirmative defenses argue that the defendant is still not legally liable. In 1983 cases, defendants routinely raise specific constitutional protections. I really want to stress that, okay? This is routine, okay? So don't freak out. You know your stuff. You vetted your facts. You vetted the prima facie elements for each cause of action. And you stay strong, okay? Their prayer for relief will look something like this. Wherefore, defendants respectfully request that this court dismiss plaintiff's complaint with prejudice. 2, enter judgment in favor of defendants and against plaintiff. 3, award defendants their reasonable attorney fees and costs incurred herein pursuant to 42 USC 1988, and 4, grant such other and further relief as this court deems just and proper. In other words, if the defendants don't make these affirmative defenses, they will lose their right to assert them down the line. Are you with me? So that takes me to the waiver rule. The waiver rule. What is the waiver rule? 42 USC 1983, under Federal Rule of Civil Procedure 8B, a defendant is generally not required to do more than deny a plaintiff's allegations to preserve their defense on those specific points. However, simply relying on denials is usually not enough to win or protect defendant's case in a 1983 lawsuit. 1, defendant must explicitly state their affirmative defenses. Denying an allegation only means the defendant disagrees with the plaintiff's version of the facts. It does not introduce new legal reasons why defendant cannot be held liable. Defendant must explicitly list their affirmative defenses like qualified immunity, statute of limitations, or Heck versus Humphrey, for example, in their first response. Continuing, if defendant only deny the claims and does not list these defenses, the court can rule that defendant has waived or lost them forever. Okay? Now, I want to talk about strategy, a specific strategy here. Because after the defendant responds, then you know that discovery is going to move forward, right? So some plaintiffs will just let the response sit there. You don't want to do that. You want to immediately strategize. You want to dissect defendant's answer. And what do I mean by that? Let's look at some things. Find their admissions. Look for facts the defendant admits. An admission means you do not have to prove that fact later in court, right? So put your energy someplace else. 2, identify defenses. Find out if the defendant claims qualified immunity, absolute immunity, or a failure to state a claim. Because you want to immediately start to look for evidence that's going to refute either one of these claims, right? And 3, follow up with the denials. That's really important. Spot blanket denials. What are we saying here? When this is like, I deny, you need to follow up on that real quickly, because the rules require specific answers, not just a general, we deny everything. Now, if that denial is critical and you need a response, a clear response, there are a number of things you can do. One, you could file a motion to strike, telling the court, listen, their denial is so evasive. On the ground, it does not follow the pleading standard. Second one, motion for more definite statement. You're asking the judge to order the defendants to give clarity to their statement. Another motion you can file, motion to deem the allegation admitted. 4, missing answers. Check if the defendant forgot to answer any specific claims, because unanswered claims may count as admissions. 5, file a motion, as I said earlier. Ask the court to strike bad or invalid defenses. 6, focus discovery. This is a huge one. Use the disputed facts to write your interrogatories and document requests. Because immediately after you receive the defendant's response, you need to start dissecting the specific responses. And while you're doing it, you should be thinking discovery. See, because you want to pin them down on this vagueness stuff. Get the court to order them to make it clear what their response is, what their position is, okay? Because after the discovery start coming in and they realize it may not be in their favor, it's too late. They've been pinned down on their response. Now, they can always go back and change. Sometimes things happen where you have to change, and it's a sincere situation, but sometimes it's not. But you need to pin them down as immediately as possible on where they stand on each of your allegations, okay? And 7, adjust the strategy. Oh, this is a good part too. Listen, one of the things I learned after having practiced for some time, it didn't take long. I learned the weaknesses in my case, or in my client's case, as a result of the defendants pointing them out. Don't panic, just fix it. What can be fixed? Fixed it. Now, if they point out a real flaw, swallow it. Okay? If they come to the conclusion that there was a flaw in your case, don't just say, they don't know what they're talking about. You need to look at that, because I've had that to happen in my career where the defendant pointed out a flaw and I had to readjust because I said, okay, yeah, they're right about that. And that's okay. Okay? All right. I trust this was helpful to you. So next week, we're going to deal with the motion to dismiss. We've talked about this quite a bit, and it is a big thing. And we're going to deal with that in video 4. All right? Well, I'm Advocate Lucinda, your empowerment lawyer, and we will see you next time.